Human rights. I have organized this conference under the leadership of our Secretary General, Teoman Aydogan. Where are you? Okay. So I would like to thank everyone for their presence, especially for distinguished speakers. First of all, of the Department for the Execution of the Human Rights to be today's discussion. Then Bianku, former judge of the European Court of Human Rights, Professor Ireneusz Kaminski, professor of the Institute of Law Studies, Polish Academy of Sciences, and Dr Kadar, chair of the Hungarian Health Committee, Dr Jesper Wittrup, international consultant in materials, and last but not least, join us lately. So thank you, everyone, to be here.
So, yes, I was wondering. There was a microphone. I wish myself to thank you, the organizers. If you have followed day-to-day activities, you see that it's not only in Europe that is what you can call democratic backsliding, or the independence of judges. So we have a topic which has at least transatlantic, not wider interest. According to the program, we shall examine how judicial independence and freedom of expression of judges are increasingly under threat. It's a major issue. And we will discuss also the broader economical implications of that problem. Because indeed, law is not just for lawyers. Law is for the whole of society. And there are topics like law and economics, and law and security, which hinge to the, or which allude to the importance law may have in all sorts of different contexts. A key player in all these areas is the Council of Europe, and in particular, its European Convention of Human Rights, which was drafted after the Second World War to draw the lessons of the past failures to organize Europe in a way which prevented new wars and which ensured economic and social progress. So, the European Convention, inspiring, as it was thought, the trust necessary between nations based on certain common values, would be the instrument which would allow European integration and unification. Have the Council of Europe succeeded? I would say one thing, that from having been one of the most horrible continents on Earth, with wars at the turn of almost every decade somewhere, we have turned into the most Pacific part of the world. So if there's something in Clausewitz's expression that war is the continuation of politics with other means, then we have been very good, because we have created politics which function. We don't need to go to war. And even the Danes, whom I said, whom we Swedes, because I'm Swedish, have been at war with regularly throughout history. We are presently nice, living together and cooperating. Oh, that was just myself. Our topic, independence of judiciary, cannot really be seen totally in isolation. You have to look in a little bigger perspective. But if we take this idea of democratic backsliding, which is at the origin of much of all this, it's an odd expression, but somehow it means that democracy goes back to its very primitive roots. That is, the winner takes it all. If you win the elections, you have a mandate from your electorate, and you're supposed to fulfill that mandate, cost what it costs. Your mandate is not to take care of the minority, it's not to take care of the welfare of the whole state. Your mandate is vis-a-vis your electorate. And to put things nicely, our more illiberal elected presidents or prime ministers and so forth call the majority the people. That gives the impression that you speak for everyone. You short-circuited all the guarantees which otherwise exist for protection of all the different groups in society. Now, to be able not to care for all these other groups, you must somehow get control over all those who could force you to take care, and thus also to slow you down in your own efforts to realize your own dreams and the dreams of your constituency of how the world should be changed. Here, of course, are major because they are guarantors of the respect of constitutions, international obligations in a number of contexts, especially European. And they can stop many things, good and for bad. If you have been in Strasbourg, you will have seen big public works for a considerable period of time because some administrative judge has said that something is wrong somewhere, and then you have to stop it, which can be quite troublesome. But on the other hand, it's perhaps a price to have the guarantee that everyone respects the same rules, and that in the long term, we all ensure that we work together and we take care of each other's concerns. I wanted to say a little thing about the business of this conference, and that is the recent attacks on the American judge who issued the restraining orders to stop Musk and the Doge team from accessing American Treasury Department's all the files with information about the whole population. I just received a copy of a letter sent out by a number of law professors asking for the Americans to stand up for this judge because he had just applied the law, whereas he was under massive attack on social media, including threats and so forth, for having obstrued laws attempts to rationalize the civil service in the United States. A typical example of what somehow we do not want to see in Europe, and where we have had examples in Poland and Hungary in the past. Of course, there's a number of other countries, even if these are the ones which have most attracted the attention of the media and of also the European Union. But this raises a number of questions. The first one is, can the national judges themselves do anything about this? And the one is, can the EU or the Council of Europe do something about this? And perhaps the third one would be to care. Is judicial independence really important? Can you live without it? Let me first address the issue of whether national judiciaries can themselves resist this backsliding. There is a lot of evidence locally from all the judgments of the European Court and the problems with even ensuring execution, and the problem the EU has had to bolster those efforts with EU pressure to achieve something with nice means. There is really little to say in favor of national judges, even with international normal support, being able to resist a thorough attack by the sitting government against their independence. That is a sad conclusion, because it demonstrates somehow how important this European control is, and asks many questions about how efficient it can be. There, Professor Fick will tell us something about her views on that. It will be interesting to hear. I will have some comments myself already at this stage. But what can then Europe do here? The EU could, in fact, not, once the problem raised a certain level of political visibility. And it was luckily some beneficiaries of EU aid which were problematic, not the United Kingdom, a positive contributor to the EU, or Sweden, a positive contributor to the EU. So somehow it's a little bit haphazard, but perhaps not only, because most of the real democratic backsliding is probably from states which have a poorer economy and less growth, and notably because they prone a system of government which is not the best for being gross national product growth. So they have to borrow money, and therefore they become dependent upon aid from notably the European Union. If you really have a good government, you should not really be in the position that you need this backslide. But I would like to stress one thing when we speak about the EU actions, namely that to use force, even economic force, you have to be legitimate. If you look at international relations in general, or the actions of everyone, they always try to be legitimate, to say that this is not just use of power because I'm the biggest. No, there's always a good reason. And here I think all the cases from the European Court, which highlighted the shortcomings in Hungary and in Poland, were very important in order to boost the sense of justification, the sense of legitimacy in the EU itself to take strong action. I often cite an old case from the early ages of the convention system. That is the interstate case against after the coup colonels in 1967. Because the colonels motivated their coup d'etat with the imminent communist revolution, imminent communist coup d'etat. And that, of course, can be an implication. But through the procedures of the convention, the European Commission, which existed at the time and was a fact-finding organ who advised the Committee of Ministers about the situation, they came back after visits and hearing witnesses and no sign of any communist takeover. And that sort of settled the matter for many political purposes. The legitimacy of the Greek government wasn't there. And the whole of Europe, all of the Council of Europe had had a good basis not to accept the legitimacy of the government. There was no discussion, because if that had not existed, you could discuss forever between different countries. Is there a threat? Is there not a threat? And so forth. Now this was not possible. It was determined, and it was determined in a trustworthy way. So the legitimacy of the government went away, and they only survived some 5 years out in the cold, and then democracy came back to Greece. But one should not forget, beyond the mere fact of having judgments and the execution as satisfaction and so forth, that the fact-finding of the court, and was also at the committee ministers stage in a number of proceedings, is very important to legitimize action by others, be it the IMF, be it the World Bank, be it the EU, be it the United Nations or others. So one should not focus only on how effective the European Convention and the execution of the European judgment is in the instant case, because there are plenty of spin-off effects. But there are some both good and bad sides to the handling of individual cases. One side which is not so happy is that the time from a complaint being lodged in Strasbourg to the implementation of the general measures necessary to solve the problem has increased. When I was working on the Rome conference back in 2000, a number of years ago, but we made some studies this time, and we came to the conclusion that for those cases which came before the court, the average time was 6.5 years, from the time a complaint was lodged and the time the problem revealed was solved. We thought at the time it was a bit long. The convention should be early warning system, so we were trying to work for diminish time to 5 years. But if we look at the same statistics today, we find that the time between the lodging of a complaint before the European Court, revealing a certain systemic general problem, and the solution to that problem is 10 years. We're going to in the wrong direction. And I think that hinges very much to the absence of resources in the system. But we'll come back to that. There is also some good news. If you see the Klima Signorinen case, which was decided recently, it only took 3.5 years. And the court has also put in place a system whereby impact cases are to be identified. And possibly they will also go quickly. But of course, it politicizes the work of the court a little bit to select cases and not treat all applicants in the same way. That is, to my mind, more easily done at the committee ministers stage, because the committee ministers is duly a political body which can prioritize things. But hopefully individuals will have gotten due redress already by the court under Article 41, so that their problems would not be so handicapped by that prioritization at the committee minister stage. There is, however, the problem of subsidiarity. That's perfectly fine with bona fide contracting parties. But when you have the country's backside and courts not playing the game fairly, proceedings will be entrenched, results will perhaps not be totally convincing, and so you have to start procedures in Strasbourg which will last a long time. So possibly it would be an idea to try to be a bit stricter with this subsidiarity when there are serious doubts as to the effectiveness of the national judiciary, especially length proceedings. When I started work here, there was a Manusakis case against Greece, in which the Commission simply said it takes too much time, the result is too uncertain, it's not a remedy to exhaust. That kind of philosophy could possibly be something to reintroduce a bit more, instead of giving all states the trust that their proceedings are truly effective. Then there is the massive practice of friendly settlements and unilateral declarations. Tens, if not hundreds of thousands of cases have gone through that procedure over the last 10 years. And they have evidently hidden a number of violations and thus prevented the support additional cases can give if they're well investigated and decided. But it's the pressure of time and money that tries to get rid of cases as quickly as possible. But the real problem with these cases is that they only give a sum of money. What is called individual measures is almost never taken into account. That is the need to reopen unfair proceedings, to reopen investigations which are not efficient, to execute the domestic judgment. And as long as it's a sum of money, it's usually paid by the Ministry of Foreign Affairs. So these cases have no effect domestically. They are not seen by politicians, they're not seen by administrators, they are not seen by judges or anyone. They are just stopped at the Ministry of Foreign Affairs through the payment of the sum of money. Now, I believe personally that that is quite a loss for the system. When we've worked in the committee ministers for decades, we have always tried to ensure that all applicants get not just the sum of money, but they get real justice before reopen proceedings, accelerate proceedings, a new criminal investigation, or whatever. But all this said, it is clear that the execution process is very dynamic and an open and inclusive process, and capable of transforming apparently easy single cases into machines for major change. The committee ministers will look at all violations in the light of all available information, not just from the government agent, but also from all civil society, from other international organizations, from internally in the Council of Europe, to decide whether this case does not in fact demonstrate a more general problem. If it does, the committee ministers will ask the state to come up with an action plan to deal with that problem. So even if few judgments come through, each judgment is explored in the furthest possible way. And that provides a lot of dynamics into the system. I will then move on to some further comments on why this judicial independence as part of the rule of law is very important. On the one hand, it's important for democracy. And if you look at history, you will see that judicial review of executive action comes with democracy. When you have a king of God's grace, well, he's of God's grace, and you will not control whether God has acted correctly or not on earth. So no, there will be no real review. But the king will, of course, have plenty of intendants and the magistrates and others controlling that people respect his will. And from that perspective, you can assure quite a lot of rule of law also in those states. That is rule of law in the sense that you have independent and trustworthy administrations dealing fairly with the people. But in the democracy situation, this things change. And one of the big fears of democracy is that the executive will not fairly implement the parliamentary acts. And that has to be controlled. And the first judicial reviews in this sense comes in the 17th century in the United Kingdom. And then this necessity emerges in all states which start to accept democracy as a way of government. And in my own country, Sweden, in the 19th century, we start to look more closely into if the government is really faithfully executing the parliamentary decisions. You can see here that this role of courts was something very important in the early years of convention. And the first cases which came before the European Court, often sent by the Commission, concerned exactly access to court, the powers of courts, scope of their jurisdiction, their scope of control over the administration, beyond, of course, the simple fact of deciding cases between ordinary people directly. And this all happened in the 1980s. And it was a very moving time. And I think there is something to say here also with respect to the links to the EU. You may remember cases like Internationale Handelsgesellschaft from 1970, or Rutilli from 1975, the last one clearly stating that among the general principles binding on the communities was the European Convention on Rights expressed. And followed by a big declaration of the Parliament, of the Commission, and of the Council in 77. Of course, we will respect European Convention. Thanks to this allegiance of the communities to the European Convention system, states started to accept fully the supremacy of or community over domestic law. Earlier, a number said we will not sell out our domestic human rights protection just to earn some monies in doing better business together. Now that the communities started to say we respect the same human rights as you do, well, then that argument fell. And the field first chosen for a major development of the convention, that is the field of judicial independence and efficiency, is probably very telling about what was considered the most important to build Europe. This, of course, also brings in the economy, because the communities who wanted all these powers to improve the economy in between European states. So from that perspective, the trust built by the convention system, both between the communities themselves and the contracting states, and in between the contracting states, was a major motor in making the European economies integrate and move forward under secure forms. And indeed, it also helped international business. I read at the time that Madame Thatcher, when she wanted to privatize British Telecom in 1984, was opposed by the Securities and Exchange Commission, because they said, you don't have a constitution, you don't have any right of property guaranteed anywhere. How do we know that if you now sell your shares on the US market, you will not lose the next elections and there will come a Labour person who will renationalize everything without compensation to our American shareholders? She said, well, I have the European Convention on Human Rights. It imposes obligations which are equal to those under the US Constitution. And we have this famous case, Borrong and Lönnroth, which has just been decided, which shows that this protection is truly effective and just as effective as the one you have in the US. Your American shareholders take no bigger risk investing in Europe under the Europe bound by the European Convention than they do back home. And that was accepted. There is a further side to this economic aspect, and that is what you can call business rights, the UNGP. That is United Nations General Principle or Guiding Principles for Business and Human Rights. It's a huge project to ensure that, notably international monetary financing institutions, but also national financing institutions and governments all go together in order to ensure that business does not abuse human rights, especially, of course, in the environmental, now in the climate field, but also slavery or slave work and much else. What is interesting here from a European Convention perspective is that when the Committee Ministers took a recommendation in 2016 to say how do we in Europe implement those United Nations guiding principles? Well, it's basically done with the European Convention of Human Rights and the Social Charter. European Convention here, not as in the area of protection of democracy, through protecting citizens or governments from, or citizens or the parliaments from excessive executives. Here it's more the positive obligations under the convention, which imposes on the state duties to design market regulations, to design responsibility and support in such a way as to care for a lot of externalia. All in all, times are dear, and I will not take more time. I think I already stolen too much of yours. I think that the problem of democratic backsliding, especially with the developments on the other side of the Atlantic, are truly becoming very urgent. And even if, for example, there are shortcomings of funds and so forth in the Council of Europe, it does have very efficient procedures which do reach out. And whilst thinking about what else can be done to prevent backsliding, I think good use of these procedures, notably at the execution stage, would be helpful in fighting this backsliding, these attacks on judicial independence, and thus on the guarantees against abusive, especially executive, but possibly also legislative action. I stop with that, and I think that the continuation of the debate is designed more to be a continuation of the ourselves, and then we have a big slot for discussion at the end. Otherwise, I think we are not sure that we all get through with our different messages. If you accept this way of acting, I would very much like to give the floor to an old friend of mine, Ledi Bianku, who has a huge experience of everything. No, sorry, you were just the first on this one among the speakers. No, it's a new friend, Professor Kaminski, who is the next speaker, and he will speak about Yalcinkaya. And I think that is a very interesting case, perhaps because it's direct at the heart of independence, but it rather shows that legislators can misuse legislative power in such a way as to impose on courts to take decisions without thinking. And that a strange way of attacking the absence of the problem of independence. But I would be very glad to hear what you have to say.
Thank you very much, Chair. Okay, so it's not necessary to use this utensil.
No, it's just for the
it's for camera, so perhaps it's better to use it. Okay, so it's my pleasure. Yes, thank you very much. I have been allotted minutes. I'm not going to abuse my time, so during this 15 minutes, I will try to summarize the case from Turkey in Polish. So I also have familiar with some other countries and problems. I was asked to prepare a couple of months ago a policy paper on this case. It's very important, and as Mr. Sundberg said, this case is not typical case for independence of the judiciary, but there are, I think, very important elements present in this case which can make us aware about the broader context for our reflection on independence of judiciary. Please let me for something. Yesterday, we went for dinner to a nice Italian restaurant, and over the taste Italian dishes, we started chatting about the topics of the conference, and we came across some ideas for reflection about the independence of the judiciary and the broader context of this concept. So we asked, for example, the question: if judges are remunerated, law, is it a relevant for independence of the judiciary, or that's not something organizational, reserved for member states of the European Union, or is it something European Court, right? If judges are poor, they likely would look for some other resources, financial resources, and that would create corruption, even structural corruption. And it worked for a couple of years in the Caucasus. And was confronted with this kind of question in practice. There were remunerated very well. So it created the problem of corruption, structural corruption, very rooted corruption. So there are different, context aspects important for our reflection, for our analysis of the independence of the judiciary. Let me start with something general before I turn to the case. The concept of independence of judiciary is constitutional. Something by its nature reserved for member states of the convention, for the states themselves. There is nothing in the convention, there is nothing in the convention about the independence of the judiciary. Of course, there is a right to fair trial. Individuals are entitled in individual cases to have their case decided by an independent court. There is nothing in general terms about independence of the judiciary. So there is a problem of finding some points of reference in order to put questions and prepare a good application to the court, referring to the European Convention of Human Rights, but having background the question, the problem of independence of the judiciary. There's something easy. But anyway, it happens from time to time, and applicants are successful in logic this type of applications. So translating or transforming, human rights issue into the general or in other direction, starting from the question of the independence of the judiciary, translating some questions into regarding human rights violations. So referring to the European Convention of Human Rights. And now the Turkish case, I'm fully aware of it. The Turkish case. Do you have cell phones? Yeah, of course, it's necessary to survive in our world. So that's obvious. We have cell phones. Do you have WhatsApp application on your cell phones? Yeah, of course. It's also necessary to communicate. It's software, communication software we use. The Turkish case is also about a certain messaging application called Bianku. This application was freely and broadly available, so everybody interested could download this application, have it his her cell phone. Downloading Bianku turned to be dangerous for those having this application on their phones. So I will explain what happened in Turkey with these applications.
From now on, you can use this one.
Okay. Perhaps you know that in July 2016 there was a coup d'etat, attempt of coup d'etat. Following this coup d'etat, Turkish authorities implemented extensive measures against individuals allegedly involved in what they called the federalist terror network or parallel state structure. Fredrik was spiritual leader. He died in October 2024. He was very important in Turkey, but at one point he split with Prime Minister Erdogan. Still you? Still. Gülen and a number of actions undertaken against those allegedly cooperating, so all being members of this network, dangerous to state. Mr. Yalçınkaya was a public school teacher, and he was accused of being a member of this underground structure, and he was sentenced to 6 years and 3 months in jail. What was the legal ground for this accusation and subsequently penalty? It was Article 313, Section 2, precisely, of this article, which makes crime membership in armed terrorist organization. So the structure was qualified as armed terrorist illegal organization. I don't know whether you are lawyers, political scientists, but even if you are not lawyers, you are, of course, with some backgrounds of law, and it's evident that if a certain act is considered a crime, this act must meet some elements, constituent elements, both material and mental, necessary for this crime. So, in case of Mr. Yalçınkaya, the prosecution and then the courts must establish that this Turkish teacher was member of illegal armed terrorist organization. What did the Turkish courts in this case? They decided that Mr. Yalçınkaya downloaded application, bylaw application, and it was sufficient to found him guilty of membership in armed illegal terrorist organization. It's something, striking. The courts might have decided this way. So no analysis, no factual analysis, no evidence that Mr. Yalçınkaya is a member. No analysis of the mental element of his action. The only evidence was that he was using this application. Period. So this it's unreasonable. But anyway, it happened in Turkey. Why it happened? Because in 2017, the Court of Cassation, the highest Turkish court for criminal cases, decided that the usage of unlock application was sufficient to bring the users of this application to legal responsibility under Article 314. So it was sufficient for the conclusion that they were members of illegal armed terrorist. So this process of reasoning or law application started from the highest court in Turkey. And Mr. Yalçınkaya, having exhausted the domestic measures, launched an application with the European Court of Human Rights. It was decided on 26 September 2023, only after 3 years. So that's good news for the applicants, not 7 years, but only 3 years. The application was decided by the Grand Chamber. So it's the biggest formation of the European Court of Human Rights, reserved for the most complex, most complicated, and most important cases. And actually, this case was important for and I will tell later about numbers for bigger part of Turkish population. The European Court of Human Rights decided that there were 3 violations of the Convention, and very briefly I will summarize reasoning and conclusions by the European Court of Human Rights. First, the Court of Human Rights found that there was violation of Article 7. Article 7 is on the prohibition of punishment and crime without law. So there is a legal basis for bringing individuals to justice for allegedly committed crimes. Why the European Court of Human Rights decided the violation of Article 7? Interpretation and application of domestic law is the principle for domestic courts. It's not a matter of the Court of Human Rights. It's domestic. By its nature, it's something reserved for the domestic courts. But the European Court of Human Rights said, of course, as a principle, we are not competent to deal with the application and interpretation of the provisions. But anyway, there was something exceptional, something for us, something for the Strasbourg Court to enter under Article 7. So that's one of the reasons why there was one chamber formation in this case. There was something exceptional in the Yalcinkaya case. The court accepted, the Strasbourg Court accepted. Also, criminal law needs some developments. So domestic courts are permitted, I would say, update criminal law to contemporary circumstances. But we still, the court, the Strasbourg Court, permit to deal with applications in exceptional case, and this case was exceptional. Why? Because interpretation of domestic courts must be. The European Court of Human Rights said reasonably foreseeable. Was it reasonably foreseeable that you are responsible for very harsh actions under law, for being a member of armed terrorist organization? There is no evidence on your membership, and there is no evidence at all on your intentions to be part of such dangerous cells. So that's why the European Court of Human Rights decided that judges to deal with this case. So the court said that the interpretation adopted by the Turkish courts was not reasonably foreseeable. Article 314, Section 2 of the Turkish Penal Code has been transformed into a striking crime of strict liability. It means that if you have this look application on yourself, you are guilty of crime of being a member of armed terrorist organization. The European Court of Human Rights used the this interpretation was unreasonably was not reasonably foreseeable. But in this seminar, stronger words. This interpretation was. I'm trying to be also elegant, so I wouldn't use harsh words. So there is something absolutely striking that the highest Turkish courts could have elaborated these legal standards. But anyway, it happened. That's about Article 5 minutes.
Yeah.
Oh, thank you. 5 minutes.
Okay.
Okay. Some words about two other violations in the Yalcinkaya case. Article 6. Article 6 also. Article 6 is about right to a fair trial. And in the Yalcinkaya case, again, there were some issues reserved as a principle for domestic courts. There was again no application, no interpretation, but also some issues regarding evidence. What happened in the proceedings in the Yalçınkaya case at the domestic level? Turkish courts relied solely on the prosecution's assessment of evidence. There was no independent assessment of the evidence collected by the prosecution. What's more, Mr. Yalcinkaya and his lawyers did not have access to the evidence due to state security concerns. So there was some evidence, but the accused and his lawyers did not have access to this material. That's something, problematic in terms of the right to a fair trial. For the trial to be fair, it must be adversarial, and there must be equality of arms of the prosecution and the defense, accused and those representing. There was nothing. There was nothing in this case. So the court decided that there was violation of Article 6 of the Convention of Human Rights. And lastly, there was also violation of Article 11 of the Convention, so the protection of freedom of association. Mr. Yalcinkaya, a member of the and seventh association, and the two organizations were shut down following the coup d'etat. And the membership of Mr. Yalcinkaya in these two organizations was also considered a circumstance involved finding guilty under Article 315. So what was legal became illegal. And the domestic courts, the mere fact of shutting down this organization treated as an evidence for making Mr. Yalcinkaya guilty. And those are my remarks. This case is important. It has been decided by the Grand Chamber Foundation, so that's important for Mr. Yalcinkaya. It's also important for generally for other Turkish. Why? Because more than 8,000 cases similar to Mr. Yalcinkaya's are pending currently at the court, Strasbourg. 100,000, I repeat, 100,000 cases similar to Mr. Yalcinkaya's are pending before Turkish courts. And generally, around 2 million people, I repeat, 2 million people in Turkey might be affected by the interpretation by the Court of Cassation in 2007. So there is a huge problem. There is a huge problem in Turkey regarding the interpretation and application of Article 314. The question is, if we are confronted with some, I would say, deficiencies of legal reasoning, interpretation and application, so solely some issues under Article 7, 6, or who are confronted with a bigger problem, the lack of independence of the judiciary, if the highest court in the country creates this striking interpretation, is it perhaps demonstrative of something going on in the judiciary in Turkey? So perhaps it demonstrates the bigger issue of the lack of independence of the judiciary. It's only, a question of myself. But anyway, I think it's to put some general questions in the highest institutions, court institutions, judicial institutions, make decisions that are striking, unreasonable. Perhaps that's demonstrative of something deeper. Thank you very much for your attention.
Thank you. I see we have a time problem. The topic is a bit too vast for us, myself included, to be within the time limit. I think one thing we could do is someone tries to contact Professor Fickfack to see if she would like to be on the air. Do we hear you? Yes. We see you also, but you don't hear us.
Maybe if you go to the mic.
Do you hear us from here?
No.
Shall we
Hello,
try?
I'm here, yes.
Yes. Now, I just wanted to ask you if your planning is such that you need to have your intervention at 15:15, or if you are more flexible.
I would prefer to have it to finish by 3:30.
Yes. Well, then what we could do, we could change the program, and we invite you to come right now if you are with us immediately, if you are prepared.
Absolutely, absolutely.
Then I invite Fickfack with huge experience of human rights and an interest in the execution of judgments of the European Court and other courts also, to tell us something about the challenges which the implementation of these judgments bring with it. Thank you.
Super. Thank you so much. I'm very sorry I can't be with you. I'm currently in a very cold Copenhagen, where we are finishing a 6-year project that we've been running since 2018, 2019 on looking at the issue of compliance or execution, like with judgments of the European Court of Human Rights. So just to say a bit about myself, I'm a professor of human rights law and international law at the University College London. I'm also an ad hoc judge of the European Court of Human Rights. I've studied the European Court of Human Rights in different ways for, I would say, about 15 years. And for the last 6 years, I've really looked at this issue of compliance or execution, and I'm using those terms interchangeably. As part of this big project, I've run a team of 9 researchers, and we have looked over this time at 25,000 judgments of the European Court of Human Rights, and specifically in that context also Hungary and Poland and rule of law cases. And really today, I was thinking that it might be interesting for you in the context of judicial independence and the rule of law, to speak a bit about the system as a whole, maybe a bit about the country, but really as a system as a whole, and the dynamics of compliance or execution within the Council of Europe. And what I'd really like to do in my time that's been allotted, I'd like to make 3 points. First one is that when we think about compliance of judgments or execution of judgments, we're really talking about the tip of the iceberg, and we'll talk a bit about the sea around it. Number 2, I'd like to talk about where compliance happens, where execution happens, and how we, in our project, were able to notice the rule of law crisis in our data before even people started to talk about it. Number 3, for us, the big question has been, for people in the room, how do you ensure better human rights protection around Europe, around the Council of Europe, and how do you do that with better compliance? So I'll talk a bit about those three things. I hope you can hear me okay.
Yeah, absolutely.
Super, thank you. So the first point I'd like to make is that we usually, when we talk about compliance, we focus on one country and we talk about that country's behavior. We also usually only talk about one judgment. But really, from our perspective, when we're looking at the whole system, we really need to think about compliance as a behavior of a state in a series of cases that it is complying in. Because if we're looking not only at one judgment, but at a number of judgments, what we can see is the strategy of that state and the behavior that the state is adopting more widely. And I would like to even expand it a bit more and talk first about the issue of friendly settlement. So since 2019, the European Court of Human Rights requires that all applications that come to the court have to undergo an obligatory settlement stage. That means that any application will for 12 weeks be sort of a negotiation between the state and the court and the applicant. In the ECHR context, we've had settlements taking place since 2000, and when we did our analysis, we found that up to today, there have been 12,000 cases that have been settled since the 90s. It is important to underline, this is why I'm talking about it in the rule of law, judicial independence context, that certain states are using the procedure of settlement called friendly settlement. They're using it strategically as a way to avoid precedent-setting decisions, and a number of countries are being allowed to make these settlements in a large majority of cases that come to the court. We're seeing countries settle 50, 60, and 70% of all of the applications that come to the court. And the argument I most often get when I talk about settlements, I get a sort of a response from the audience is that these are only repetitive cases. We have looked at our 12,000 cases. We have found that these are also rights to life cases. They're also torture cases, and that they're also law cases. Now, why do I mention the issue of settlement in the context of rule of law and compliance? Because our analysis has actually shown that even before we start talking in Hungary, for example, about Orban taking over, or before we're starting to talk about court packing, what we are seeing in terms of the dynamics of, let's say, Hungary's behavior in front of the European Court of Human Rights, we see this big jump in 2010 with Hungary quietly settling twice as many cases as there are judgments coming out of the court. So let me give you an example. If Hungary, on average, every year has about 30 judgments coming out against it, it is also, in addition to those 30 judgments, settling another 50 to 80 cases every year. And it is doing that until 2020 or 2021, from 2010 to 2021. So about 10 years of settlements. Now, this is really what we are identifying as an approach of avoidance of judgments that we are, for example, not seeing in Poland. Poland is taking a much more confrontational approach to the European Court of Human Rights and is refusing to settle any cases that come before it, and it goes in defense of its authorities very clearly in front of the Strasbourg Court. So, for us, settlements are really an important indication of the state's behavior, how the state chooses to behave, but they're really examples of states trying to avoid international institutions or seeking confrontation with them. They are strategies to avoid precedent-setting judgments that require compliance. So it's a way of preventing the need for compliance, if you would like. And they are, it's a strategy that essentially allows the state to avoid being told off by a court. So from our perspective, seeing the beginnings of the rule of or problems through these even before they become visible internally. So from our position, when we think about compliance with judgments that have actually come out of the court, we think that that is really the tip of the iceberg. And what we're not seeing underneath are all of the cases that never made it in front of the European Court of Human Rights because they have been settled. And so when we think about the cases that were mentioned by speakers that came before me, the Yalçınkaya case and other cases, right? Those are cases that actually made it, but we need to be concerned also about the cases that never make it because they're settled. Those cases never make the law, and they also don't trigger compliance. So that's my first point. My second point is, where does compliance actually happen? And as part of our analysis, we looked at 10 different countries of the Council of Europe, and we wanted to understand who are the actors within each one of these countries that were, we call them compliance actors. So who are the actors that were responsible for implementation? And we mapped out domestic courts, we heard a lot about, mapped out the government, parliament, we mapped out civil society, we mapped out NGOs. And we wanted to understand both the type of cases that these actors were involved, but also the full net. Now, the question for us was, are these structures or networks of compliance, are these centralized? Are they decentralized? Do they mobilize only in enhanced proceedings cases or in standard cases? And how does the structure affect compliance? So, for example, what we found in Hungary, just to go back to this case, we found that it's a very centralized network. So when a judgment is rendered and it comes to Hungary, it travels to a department called the Human Rights Department within the Ministry of Justice. And this kind of centralized picture is a very traditional picture of a number of other countries, the compliance structures that they put in place. So having one department that is responsible for coordinating all of the compliance and implementation. Now, this centralized structure can work really well when it works. But when the process of compliance doesn't work, when the central actor, like the Human Rights Department is disabled, when it is hollowed out, then compliance is just not going to happen. So what we have found, for example, in Hungary is that in 2014, the Department of Human Rights is legislatively stripped of its competence to, for example, disseminate rulings to the judiciary. That means that there's no communication all of a sudden with the judiciary. We find that instead of the Human Rights Department coordinating all of a sudden, as it normally does, compliance and execution, what it ends up doing is becoming silent and merely reporting what the government did to the Committee of Ministers. And what we find that it's really the government taking over its communication with the Committee of Ministers and with deciding what's going to be complemented and whatnot. So the Human Rights Department, the central power broker, the central actor, should be facilitating execution within Hungary, but we've seen it also in other countries, essentially is hollowed out during this rule of law practice, both legislatively and in some sense physically or practically. And it means that there just essentially nothing is happening. But the Human Rights Department isn't the only actor that has been hollowed out. We also looked at what happens to the courts and whether or not we can see in this network, just through the absence of links that used to exist, how relevant courts are to compliance. And we see, for example, the Supreme Court before 2010 being super important in internalizing judgments of the European Court of Human Rights domestically. And it's what we would call a highly influential node, influential actor in the compliance network, really taking the decisions and making it, internalizing it domestically. And then as the rule of law issues arise, as we get court acting, as we get other interventions, legislative and constitutional, into the judiciary, into the courts, essentially the Supreme Court loses its relevance, loses its influence and its connections into the networks, and becomes a disabled organ that is unable to really participate anymore in execution. So what this tells us when we speak about compliance or execution is that we're not only thinking about what countries do in response, what kind of remedies they take, and what they offer to undertake, but more importantly, who is taking charge of the process? Is it the people who've been there for a while, who have the know-how, or are those people disabled and we've got new people coming in, new institutions, new organs? And this is really important. We see that these kind of centralized networks really work well when we have people who have been trained, who have traveled to Strasbourg, who know people in Strasbourg, who can pick up the phone and say, how should we comply with this? How should we execute this? People who regularly engage on the international level, those types of relationships work well, and compliance and implementation works well. But once we've taken those people out of the equation, the only thing that remains is essentially pressure from NGOs and civil society. So from our perspective, our second story is that we believe that states should commit, and we have to encourage them to build and establish compliance networks that are resilient, regardless of who is in power, regardless of who is the leader, or who is in the government. And in certain circumstances, a decentralized network where multiple actors, like here in Denmark, actually works much better because somebody else can step in once an organ has been hollowed out. And this then brings me to my third point, which is about how can we achieve better human rights protection and better compliance across the whole of Europe. When we think about compliance, when we think about execution, we always usually speak about one case and we speak about one country. Maybe we do a bit of comparison. This is what a country A behaves like, this is what a country B behaves like. We have known is that we have to start thinking about execution and compliance as a behavior of states within one system of the Council of Europe. So generally, the court will be silent on what needs to be done in relation to a judgment. It will be for countries to decide what they will propose in terms of remedies, in terms of what they want to do to a judgment. They may say they don't want to comply, but that's quite rare. And so when states are deciding what to do, what they often do is they speak to other states. And if we think about that, if states are picking up phones and saying, what did you do? What would you allow me to do? Or if they get into the Committee of Ministers and agree what would be acceptable. This means that these states are learning from each other. They are sharing their experiences, they are imitating each other, and that they will imitate the same behavior that came before them in another case. And we're seeing that with a number of countries who are using, for example, isolated case argument. So they come to the Committee of Ministers or to the Department of Executions and say, actually, this is an isolated case, you should close it, we don't want to engage with it, or just disseminate it. We're seeing a number of countries use that argument increasingly as they've seen it with other states. So our concern here really is a concern of imitation, a concern of contagion. If good behavior is contagious, bad behavior is even more contagious among states as it is. And so we need to intervene into the system. And when I say we, I mean NGOs, I mean civil society, I mean the Department of Executions. The Department of Executions I underline because it sets the guidelines and it sets the threshold on what will be acceptable in terms of remedies and functions, but also in terms of when we will close a case. And we have to have high expectations for states when they choose their remedies and in terms of when we will allow them to close a case, when we will allow them to say, this is enough to comply. We need to do that because if we let states get away with little, if we get states, if we allow states to adopt compliance minimalism, which we see across the whole system, then there is no point having this system. And so I would really encourage, and this is sort of my third takeaway, that we, NGOs, civil society, the Department of Executions, us academics, really find different ways of intervening into the process of execution, compliance, also through a conference like this. And we do that by showing what the appropriate remedies in a specific case should be, by reporting on what remedies actually have been implemented, by giving information to the Department of Executions about what actually has occurred, what remedies have not been adopted, and by asking all of these actors to set the bar there, so that we can ensure the states are held accountable, not only at the court level, but also when it comes to executions, to the execution of judgment. So when I think about compliance and the dynamics of compliance and non-compliance, the takeaways from my talk are really three. One is that when we think about compliance, we're only talking about the tip of the iceberg. There's a lot of the behavior that we don't know about that is settled away. Number two, when we talk about execution and compliance, we need to be thinking about who the actors are, how do we protect them, how do we ensure that they survive a change of government, a change of politics. Number three, when we're thinking about execution, we need to think about protecting the system as a whole. And we need to expect of the state, all organs of our government, more, and not allow them to get away with compliance minimalism. I'll stop there. Thank you very much.
Thank you very much.
Thank you so very much, also the chair. Perhaps also as time is running, but shall we make a small break in the sense that we allow some questions to Professor Fickfack at this stage, since she may not be able to be with us later. What she has told us is, of course, extremely important because it goes to the heart of what makes the efficiency of the system. And I have some questions myself, but if there are questions from the floor, we may perhaps open up if you agree with this.
I'm very happy to.
I have a first question that you said about friendly settlements. I made a similar study to yours for 2010 to 2020, and I found roughly 30,000 unilateral declarations and friendly settlements. I dealt with them in the same way, because many friendly settlements with this procedure before the court are rather forced upon the applicant than anything else. But that's a huge amount. And I never had the time to look through them as you to see what was in all these cases. But you certainly go down the same line of conclusions that in the execution department we thought was right, namely that a lot of interesting cases never get through. And this brings us to one very important conclusion. Of all this work, only 200 cases a year, roughly, are really leading cases, setting in motion some kind of legislative reform or something like that. And of these, in less than 10%, you have some guidance from the court. The rest of that work is carried out in the procedure before the Committee of Ministers. And I think that there is something to say in favor of that procedure, in that it does create, as I try to say myself, big machines which change out of very simple judgment, because the judgment is seen in the light of all the information available to the committee as demonstrating the general problem. And states usually accept that. the committees. So that I think is a very positive sign that small judgments are accepted to be able to reveal much more than what is apparent from the simple conclusions in the judgment. This, which I think is noted, and which it would be interesting to have your view. Those group cases, that is, once we get cases which approach a certain problem like that of judicial independence from angles, we start to group them. We can have a group of arbitrary application of criminal law in Azerbaijan. We can have a group of arbitrary detention. There can be this grouping of cases is very important to visibility. And then that is something which is so and so used, is something certainly which could be another tool to improve. Because notably with Hungary, if you look at what is in the caseload, there is a huge case to be made about arbitrary application of law in Hungary, beyond what you said about the organization of the agent's office. And on that side, I would just like to say that sometimes it's a bit difficult to see what a reorganization means. In Russia, for example, the execution was first under the president. Then came Yukos. That was a case which challenged him personally somehow. And so we understood when he transferred the obligation to execute from his own office to the Minister of Justice, even if that was slowing down. But we understood that the president might not be so keen on executing a judgment which goes against himself and his authority. So, but at the end of that, we still had very good cooperation with people. And so the simple major change wasn't very negative, in fact. You have to dig a bit deeper. And the last comment on that is that this is perhaps an area where civil society must help a lot, because diplomatic or a committee prevents the Council of Europe bodies from challenging the internal organization of the state. There is a good faith presumption in all the work in the Council of Europe, which is very difficult to break. You really have to behave very, very badly before that is possible, and then possibly it's even too late. These are some remarks, perhaps including some question bits. Would you like to comment on any of these before I give the floor further?
Yes, thank you so much for those comments. I think they're really important. So one thing I'll mention on civil society and NGOs, what we have found is that in a number of countries, civil society and NGOs don't get really don't participate in the execution until the case has become enhanced in terms of proceedings, or until it becomes a political court. And in some sense, it is cases are not closed quickly that NGOs really become super important and play a really big role. And I think the Department of Executions is also really underlining the need for these actors, these institutions, to provide them information, because they're not able to know everything that happens internally, everything within the borders of the country, or not what the state has provided is actually true or not. So I really underline that the role that civil society and NGOs plays. I think on the rest, I agree, and I'm very grateful that you mentioned your own work on friendly settlements. I think friendly settlements are a thing that has been understudied, and yet it represents so much of what the court does, the registry does. And I think it's becoming more and more prominent, because a lot of the things you described are really a result of the workload that the court is facing, and therefore it is trying to settle all of these things. It is trying to group cases, etc., and it is deferring remedy, definition of remedies, agreement on compliance to the committee of ministers. It is doing all of that so that it says, this is not our task. We want to focus on those 200 cases. And I understand that decision, but it is a structural decision that then has means a lot of these questions become. Thank you.
We have some further comments from the floor. I could raise a short further remark. If you read what the court says about its role, it's usually that its role is to decide individual cases and provide individual justice. That is not the role the court has when you get documents from the Committee of Ministers or more political. There's a strange hiatus between the perception of itself and the perception from the outside of what role it has in Europe, which someone might wish to work.
Yeah, agree.
Well, then I think we thank Professor Fickback for this very elucidating description of both some strengths, but also many, many shortcomings in the general function of the system, and how it is difficult, especially with the countries which do not wish to play the game, to really find tools to reach out and change things. But we'll hear more from this positive here in the very near future. So thank you so much, and we will hopefully be seeing each other again in different contexts.
Thank you very much. Have a lovely day.
Now I'm a very lousy chairman because we are way out of time. But on the other hand, I think that the things which pop up are highly interesting, and possibly since we have gathered here and we do have the time to run over time, we will do this. Shall I now give the floor to, I think it is Ledi, eventually?
Thank you very much, Fredrik, and I thank the organizers of this event, which has already been mentioned, deals with a very important topic for Europe, and as you mentioned, Fredrik, not only for Europe. Now, I've been asked to speak about the case of Baka versus Hungary. I'm not going to go through the judgment because, of course, you can read the judgment on the internet, and we don't have time. I have 15 minutes, and my presentation here is like 11 pages, so I'll focus on some of the most important aspects of the judgment. But before speaking about the judgment, let me mention, kind of, it's not an anecdote, but it's history around the case of Baka. And to show how the European Court of Human Rights was itself concerned about independence of the judiciary at the court, within the court, in dealing with the case of Baka. Why? I'll speak only about my personal subject. Other judges dealing with the same issue are sitting in Baka. But when the formation came out, I saw my name, and I went to the president and I said, the president was the Italian president. I've met once Mr. Baka, because when Mr. Baka left the court in 2008, I joined the court. And I just said hello once. And I said, we've been also sitting in one judge in the case. He was ad hoc judge. So tell me whether this kind of two events are for me to ask for recusal from the judge. Sorry? I'll close it. Oh, that's better. Thank you. So whether these two events raise any kind of, well, suspicion was not any kind of suspicion because I didn't have any kind of information or exchange with Mr. Baka about his story or whatever, but is also a question of appearance. whether these events would appear like the court, myself, being not independent. And it was the president who decided that I should continue and deal with the case. And as I said, several other cases were in the same section, etc. They found other solutions, but just to bring you within the so Baka deals with the Baka judgment deals with the issue of and more specifically, and also with 10 of the convention, the freedom of expression judgment. When we speak about Article 6, well, this is not the first case the court has been dealing with the independence and impartiality of the tribunal established by law, which is a notion included in Article 6, paragraph 1 of the convention. There have been also old cases, for example, Stramek versus Austria in 1984. There has been another case which I consider as one of the most important, legally perfect cases of independence of the judiciary, which is Alexander Volkov versus Ukraine in 2013. One of the strongest as well, because the court ordered the reinstatement of Mr. Volkov at the Ukrainian Supreme Court. And we are dealing with a country, probably in judicial terms, higher corruption of data amongst European member states of the Council of Europe. If I move to the case of Baka, which was delivered in June 23rd of June 2016 by the Grand Chamber. And it is interesting because there was a chamber case finding violations in Baka. The case was decided by the panel to be sent to the Grand Chamber because of the growing importance of the topic at the time, 2015, 2016. The Polish scenario was coming in. So the court wanted to show that it was answering to some of the most worrying messages coming from some member states, in this case, Hungary, but also there are some other states which were showing worrying attitudes. In the case of Baka, the court is a Grand Chamber, as I said, one of the first Grand Chamber in relation to the judiciary as such. And the court said, so the Grand Chamber said, the notion of the separation of powers between the executive and judiciary has assumed growing importance in its case. This is a quotation from the court. The same, says the Grand Chamber, applies to the importance of safeguarding the independence of the judiciary. So they are both linked, independence of judiciary and separation of powers. And the court, these are the general principles elaborated by the Grand Chamber. Which is also interesting in Baka, is that the court tries to establish a kind of catalog of international instruments in dealing with independence of the judiciary. Because we shall also remember that there are many other institutions, not only Council of Europe, like the Consultative Council of Europe, who basically controls all the judicial reforms in the member states, with few exceptions, with the only exceptions which are problematic. Within the UN as well, there are very kind of organization of judges. The UN has also a special rapporteur on the independence of the judiciary. So the Grand Chamber uses the opportunity of Baka to some of these instruments. And for example, it refers to UN High Commissioner for Human Rights, a general comment to an Article 14 of the International EChR, right to equality before courts and the right to a fair trial. So takes this into account. The Universal Charter of the Judge, the Bangalore Principles on the Independence of the Judiciary. So takes these, and also the work of the Consultative Council of European Judges. Then it deals the main issue in the Baka case. The main issue was Mr. Baka left the European Court of Human Rights, where he has been the Hungarian judge for, if I remember correctly now, for almost 50 years, between 1993 and 2008. He went back to Hungary for a year or so. He was president of the Court of Appeal. Then he was appointed president of the Supreme Court in Hungary. After Mr. Orban came into power in 2010, he started a series of constitutional reforms, amongst others, with the composition of the courts. And one of the measures was judges shall not retire anymore at the age of 70, but at the age of 62. Most probably they would love it. If you have followed the debate about the pension reform. Another measure was that a president of court, and this was ad hominem measure, should have been exercising for more than 5 years in a row a judicial position in Ukraine, which was not the case of Mr. Baka. And the exercise of judicial functions in Strasbourg didn't count. So it was really tailored for Mr. Baka. Then the court had to reply to this issue. And it says, in relation to the removal and sanctioning of judges, because Mr. Baka was obliged to leave the Supreme Court as a president, not as a judge. Factors relevant to safeguarding their independence include the reasons for which judges can be removed and or sanctioned, who or which body carries out disciplinary proceedings against them. It takes into account specifically the minor power of judges, which provides, underlined in a specific provision, that at least 50% of the members of the disciplinary body sanctioning judges shall be composed of serving judges. This is the constant line of the Strasbourg court, including the very recent Armenian case, Antonian 3 weeks ago, with the exception of Albanian case. There is a big exception. There are no judges, the members of the disciplinary chambers in Albania. And the third point, which makes the court in relation to these standards, is the procedural fairness of disciplinary or removal proceedings. This statement is in Baka, has been confirmed in Ramos Carvalho versus Portugal Grand Chamber case. Then the court in paragraph 64 says that international and Council of Europe instruments, as well as the case law of the court and international court, attach increasing importance to the procedural fairness in cases involving the removal or dismissal of judges. In particular, they specify that an authority which is independent of the executive and legislative should be involved in every decision affecting the termination of office of a judge. And then it continues to cite several Council of Europe instruments in regard, which deal with the issue of the independence of the body concerning deciding on the mandate of the judge. In paragraphs 72 to 86, it underlines the following: judges shall be subject to suspension or removal only for reasons of proven incapacity, conviction for a crime, or behavior that renders them unfit to discharge their professional duties. It also adds, standards should be prepared and published to define not just the conduct which might lead to removal from office, but also all conduct which might lead to any disciplinary steps in change of status, including, for example, a move to a different court or an area. There have been several Turkish cases that the transfer of judges, and also Polish cases concerning the transfer of judges through unfair procedures. And the court says, at the end, decisions in disciplinary suspension or removal proceedings should be subject to an independent review with the possibility of recourse before a court with the full jurisdiction. So this is critical. Mr. Baka didn't have the possibility to go before court. It was automatically a violation of Article 6 of the Convention. Then what is interesting in the case of Baka is Article 10 as well. Why is that? Because Mr. Baka, being the president of the Supreme Court in Hungary, was at the same time, ex lege, president of the National Council of the Judiciary. So the body that assesses all the judicial. So when the Orban, the third, was the second Orban government at the time, 2010, started with the new reforms in relation to the judiciary, Mr. Baka, especially in his capacity as president of the National Council of Judiciary, started to speak out what he thought were interferences with independence and impartiality of the judiciary. He spoke in the media. He also spoke before the parliament, also in judicial gatherings. Now, the question was that after these positions taken out in public, the sanctions against Mr. Baka were. Then the court had to elaborate very interesting position in relation to the freedom of expression of judges, what judges can say and what judges cannot say in the framework of Article 10. Let me mention a few of the most interesting points from the judgment. The court says that it has been already affirmed that Article 10 applies to the workplace and that civil servants and to the civil servants, including judges, also enjoy the right to freedom of expression. It also adds expression by judges on matters of public importance benefits from high level of protection under Article 10. Any restriction imposed on the freedom of expression of judges must not have a chilling effect on their willingness to participate in public debate on matters concerning the judiciary especially. For example, legislative reforms or issues concerning the independence of the judiciary. In this context, the court says, will therefore be the case that it is not only the right, and this is important, but also the duty of a judge to express their opinion on reforms affecting the judiciary. And this position by the court in Baka has also been confirmed later in the case of Kovesi versus Romania in 2020 and in Zurich versus Poland in 2022, where the same issue came up. The court continues on to fine-tune. It says the context in which a judge has spoken, expressed an opinion, or acted, and the reasoning behind the decision to sanction a judge are relevant to this assessment, whether it is proportionate. For example, disciplinary measures taken against the judge based on their expression of views in a public forum, such as when the judge delivers a public lecture, makes a statement to the media. This has been considered Wille versus Liechtenstein in 1999. Statement in the media in versus Russia in 2009. Writes letter to politicians or members of public office, or delivers a speech or issues a public communique, as it was the case in Baka, all constitute interference with Article 10 of the Convention. However, because there is paragraph 2 of Article 10, so we have to be careful of maintaining the independence and impartiality of the judiciary. In assessing the proportionality of the interference, the court recalls the exercise of these freedoms, of freedom of expression, since it carries out with its duties and responsibilities, may be subject to such formalities, conditions, restrictions, or penalties as prescribed by law, which are necessary in a democratic society for the protection and reputation or rights of others, or for maintaining the authority and impartiality of the judiciary. The main issue is that the judge cannot speak about a specific case. He is part of the formation. He is going to decide. So the court kind of takes the time to clarify this because it's extremely important. It has been later dealt with in the case of Maurice versus France, in 2016. So where the issue was that the judge had taken a position in a case, and later he was part of the formation in deciding this case. So the court continues, the protection of the authority and impartiality of the judiciary is therefore a legitimate aim in pursuit of which the right of freedom of expression might be restricted. So judges must be careful. However, then shifts the balance again, recognizes this legitimate aim for restriction. And the court says in paragraph 156 of the judgment that whoever state cannot invoke the independence of the judiciary as a reason to sanction a judge for the exercise of their freedom of expression, if the measures taken against them would in fact have the opposite effect. So it's a careful exercise that the court is conducting here, especially in relation to Article 10. For example, continues the court, the early termination of a mandate of a court judge as a consequence of their exercise of freedom of expression that could undermine impartiality, where their termination was not in accordance with law, did not relate to any grounds of professional incompetence or misconduct, and did not relate to speech, which was itself harmful to impartiality. So these are the two main takeaways from the Baka judgment. To the Baka judgment, the Judge Linos Alexander Silianos, later to be the president of the court, attached a concurring opinion. He did agree with it. However, he raised a very interesting issue, which now, with the benefit of time, I think I did not join him in the opinion, but with the benefit of time, I think probably it's right. It was the right moment to bring this issue and to support this issue. His point was, are we assessing the issue of independence of the judiciary from the institutional point? So seeing the judge as part of the state structure and as an actor in conducting affairs of it? Or shall we also raise the issue as the subjective right of the judge not to be removed, as the court has done, for example, in the case of public servants, Escalinen versus just to mention the case. And this is a very kind of interesting, well, not only doctrinal, but also kind of debate with some substance in order to give a better protection, the most effective protection of the independence of the judiciary. Baka intervened in a very critical moment. Then there are few cases not of the same importance in Strasbourg. However, I must say that as far as the Polish judicial reform was concerned, working in Strasbourg with the court, I'm somehow jealous, but we must accept this. The European Court of Justice in Luxembourg intervened with some extremely powerful judgments. June 2019, November 2019, and then all Commission versus Poland, AK versus Poland, and a series of cases, both preliminary rulings or direct actions by the Commission. And they've set up the scene, really. I was pleased as well to see that Baka served as a reference to all these cases, most of these cases by the European Justice. But I must also recognize the fact that the European Court of Justice established somehow much more autonomous concept of independence and impartial tribunal established by law than the Strasbourg Court tends to be, to a certain extent, more deferential to national law, especially see Astrakhan versus Iceland in December 2020. The European Court of Justice has elaborated a more solid, which then in turn has been followed by the Strasbourg Court in all the line of Polish cases. But this was my role in explaining the Baka judgment. If questions to answer or participate in the debate. Thank you very much.
No, thank you. I mean, time is running, and we have at least 2 speakers left, plus some summary, but we'll make it short. Could either relax and take questions here and now, because I will not leave you to go to heaven. Good, but it could be, so if someone has a question on the Baka and what it means, I mean, this is a moment where you could question a person who was very much involved in this case. No? Well, but it was truly, I mean, at the execution stage, I can say we were fascinated by the case and also by what it meant. But I have a feeling that possibly if the floor to Andras Kristóf, that helped to understand back a bit more than I would be able to do.
Thank you very much. Do you mind if I stand up? Does that create any problem regarding streaming? No. Just I'm a lawyer. I'm used to when I speak, and you are now my judges. So basically, yeah. So Baka came. It's an extremely important decision that came in a context. The context was the Fidesz government, the government of Orbán, gained a landslide victory in 2010, giving a constitutional majority, meaning that anytime they wanted to change the constitutions, not just local laws, they could have support from any opposition party, which created an enormous chance for them to really kind of undermine and attack the system of checks and balances in a legally and procedurally impeccable way. That's one big difference between what happened in Poland and what happened in Hungary, that the Polish government that started a kind of illiberal term in Poland did not have that luxury of having a constitutional majority. So after 2010, this very first incremental, but then accelerating, but very conscious attack on system of checks and balances started. Basically, the execute with the help of the legislature, try to undermine, eliminate, or occupy any actor and institution that could control the executive in any way. It started with the state institutions, constitutional court, the ombudsman, then it went on to the media, civil society. It's a long story, but obviously, you know, your first target would be, after the constitutional court, I think, the ordinary court system. So the judiciary had its share of the attacks. And the Baka decision, and also the early retirement of judges, which meant getting rid of the older judges. Older judges tend to have, you know, administrative positions. I mean, you become an administrative judicial leader after you have some experience. So administrative judicial leaders were highly overrepresented among older judges. So it was an attempt basically to get rid of those judges who had these positions with the view to actually having new people there. So it wasn't by accident, or it wasn't because our legislature felt sorry for these judges who have been serving for so long. And Mr. Baka's ad hominem removal was also part of this series of attacks on judicial independence in the context of trying to get rid of all the controllers of the executive. Now, judges in Hungary have turned out to be very resilient, I have to say. So where is the, I will refer to this as the government, because you don't have a slash between the government and legislature in the Hungarian context. It's not the parliament having a government, the government having a parliament. So please forgive this kind of inaccuracy. I'm going to refer to this as the government. There are, of course, legislative measures behind this. So the government could easily undermine or occupy almost all the actors in the arena. With the judges, they had a tough time, and after a while, they realized that they cannot domesticate this 3,000 Hungarian judges. What they started relatively recently was just going for the High Court. And it also happened through the ad hominem legislation that made it possible for the government to get the Curia president, to whom I will refer frequently, who actually, before he became a Curia president, did not really have strong judicial experience, but he had some scientific activities. And this, what you see here, is the most dangerous branch of power, is something that he wrote in one of his articles. So we now have a president, a high court president, who thinks about the judiciary as a very dangerous branch of power. Now, the freedom of expression of judges has become a kind of battleground between the judiciary, trying to preserve their resilience and independence, and the government, which is trying to domesticate. This is something I can skip. You have a picture of Mr. Baka, so I think this slide is not useless. Judge Bianku has very nicely summarized the most important conclusions of the Strasbourg Court regarding the freedom of expression of judges. It can be limited to proportionality, but they must public independence under threat. It's not only a right, it can also be a duty under certain circumstances. And here you have an important sentence in the judgment that Mr. Baka, the chilling, discouraging other judges from participating in public debate, just affecting the independence of the judiciary. It's not the only victim of this violation, but the whole Hungarian judiciary is, due to that chilling effect, that is removal from a very high and in principle protected constitutional position, can mean on judges of the lower tiers. Now, the Baka judgment has not been executed. This is one of those several Hungarian decisions or judgments of the Strasbourg court which have not been executed. It was handed down in 2016, so it's years now. One of the things where the Committee of Ministers constantly reminds the government that they should do something is exactly the freedom of expression of judges. Hungary's position is there's nothing to be seen here. It's all good. We don't have a problem with the freedom of expression of judges. And this is what they say. Hungarian legal provisions, particularly this section of the Judicial Status Act, makes a restriction only in the making of statements related to adjudicating activities. That is the only limitation we have, and it's through section 43. It says that the judge cannot inform the public about ongoing cases, nor closed cases. Judges and the judicial system communicates about adjudication and adjudicated matters through court president appointed spokespersons. And that's fine. The problem is that this statement of the Hungarian Action Report or Plan, I can't really remember which, is highly misleading and erroneous, because you have two other sections here. One is the judges shall not conduct any political activities, and the other is that they should behave in a manner that does not violate the authority or undermine the authority of the courts or the trust in the judicial procedures. And these are pretty broad categories. And now the big question is, when there is something that is happening in Parliament, when laws regulating the judiciary are amended and the judge might say that, hey, it's not okay, is that political? If, for instance, and we will see examples for that, a judge talks to the public and criticizes organizations that are there to represent judges, that they are not doing their job properly, are not defending judicial independence sufficiently. Do they undermine the authority of the court? Do they undermine the trust in judicial procedures? These are debatable things, and of course, what is happening is that from the government and from also the president of the Curia, who is a political appointee, he was not elected by the judiciary, he was elected by the Hungarian parliament. He was elected actually against the National Judicial Council, which is the self-government body of Hungarian judges. So we have this debate regarding recent amendments to laws concerning the judiciary, whether they fall under political activities, whether they are capable of undermining trust in the court. In that regard, the Baka judgment is an extremely important assistance provided to Hungarian judges who are protecting their own independence. Now, the National Judicial Council, not this one, but the previous one, which was a very progressive, from the government's point of view, rebellious National Judicial Council, tried to lend a helping hand to Hungarian judges when they passed the new Judicial Code of Ethics, where they tried to, in the absence of clear regulations, clear primary laws, try to clarify what a judge can actually say and what a judge cannot say. And here you have section 42 of this Code of Ethics, which proclaims that judges may freely express opinions regarding laws, the legal system, and the administration of the court. So you are in the green when you're talking about these things. What happened here? You remember the Curia president who thinks that the judicial branch is the most dangerous branch of power. He challenged the code before the Constitutional Court, which is a highly packed, loyal institution to the government, claiming, among others, that this is a significant expansion of the freedom of expression, and this is the authorization of judges to criticize laws and the justice system, which is not in compliance with Section 37 of the Judicial Status Act, which is the ban on behaviors that might undermine trust in the judicial system. So the Kuria president, who is a parliamentary electee, challenges before the Constitutional Court this provision, which is perfectly in line with what the ECHR said in the book. So you have this battle raging in the Hungarian judiciary. And when you look at the practice, the Hungarian Association of Judges conducted a survey among judges. It was anonymous, it was public. Where approximately 10% of the Hungarian judges responded. And you see in a couple of numbers here, 86% of the respondents said that there was a chilling effect when it came to judicial freedom of expression. Over 70% knew about cases from the past 5 years when a judge faced negative consequences for speaking up in relation to judicial independence. Those judges who responded that they prefer not to speak about this subject said that the prospect of retaliation was what held them back, and 82% of judges believe that we are not able to participate in public debates if they have political connotations. 41% said that not at all, and 41% said not really. Also, I will skip this. I'm not going to go into details due to the time, but we have individual cases to show that we have serious problems with judicial independence and the freedom of expression when it comes to this. He was the head of a judicial panel at the Kuria, which handed down judgments that were very, very unpleasant for the government in politically sensitive cases. He was the head of a panel that delivered some really brave decisions in a difficult political situation. And what then came reorganization of the judicial panel. Basically, what happened is that the president is they reorganized, basically set the rebellious, among others, panel, and his panel ceased to exist basically. And the judges he used to work with were distributed among other judicial panels. What he did, he wrote an article about it. He didn't go out to the public claim. So he didn't make any horrible claims about the Kuria president. He wrote a scientific analysis about this whole process of how his panel was reorganized. And then the Kuria president banned the publication of this article. So if you go to the link to the article, the database of Hungarian scientific articles, you can see this article can only be read with the permission of the Hungarian Kuria. No one has ever received that permission. And also a series of administrative procedures were launched against Judge Kovács. Actually, the Hungarian Helsinki Committee is providing him with legal representation, so I'm not fully unbiased in this case. Those judicial proceedings are pending. Here you have a very concrete example. And the most recent development, I'm going to stop my presentation here. There was a mention of the judicial salaries in Hungary, which are extremely low. I think they are among the lowest in Europe. And the big problem is that they haven't been raised in 3 years, basically, with very high inflation in the meantime. So these salaries lost about 40% of the value within 3 years. Now, whether there's a raise or not depends on the legislature, which is pretty obvious. Then one branch of power is in the hands of another branch of power. And actually, there are some professions in Hungary, including some governmental positions, where you have a kind of automatic system that, with the rate of inflation, these salaries are corrected. So it would not be unprecedented to have a kind of autocorrect system. But I think there is a reason why there is no such system, and it's exactly the kind of being able to put pressure on judges. And an example of this was in November 2024, when an agreement of the Ministry of Justice, the Kuria President, and the National Office for the Judiciary, which is the institution regarding judicial administration, and the National Judicial Council, not the previous rebellious one, but a new one with a new composition, signed an agreement, a tripartite agreement, which basically said that we are going to raise your salaries, and in return, we want your support for certain judicial reforms. And then the agreement outlined some of those reforms, but and some of those reforms were actually very problematic from the point of view of judicial independence. For instance, now the retirement age for a judge is 65 years, and actually one of the suggested reforms was that with the permission of the judicial leader, the judge can keep serving until 70, which means it's a discretionary decision, not with no objective criteria. So here's that's a way to put a pressure on the judge, actually, that, you know, if you behave, I'm gonna let you, you know, keep serving. So basically the reforms that were envisaged are problematic, and there was disagreement. And then the judges, the Hungarian judges, just had really enough, and letters of protest were posted on the website of one of the two Hungarian judicial associations with judges close to I don't know what I still have it here. So close to 1,000 judicial employees signed these letters. There was even a demonstration that forced some judicial holders to resign, and finally the National Judicial Council withdrew its approval from the agreement. And now you might say that this is a sign that actually there is no chilling effect, because look, these judges dared to actually voice their opinion. But if you look at the letters of protest, when I say 800 judges, some of those remain anonymous for the fear of retaliation. So some of the letters of protest are signed by one or two judges, and then there you have a sentence saying that another 40 colleagues support it, but they wish to remain anonymous because they are in fear of retaliation. That's one thing. And the other thing is that in this whole situation, the service court presidents, service courts are courts within the court to deal with disciplinary issues regarding judges. Service court presidents said that we believe that participation in these protests are part of the freedom of expression of judges. This is about judicial independence. This is about issues where judges should be allowed to speak their minds. But the Korea president launched a very fierce public attack on the service court presidents, calling them, telling that they overstep their authorizations, and then they are deceiving judges. So what you can see there is an ongoing battle for judges' ability to actually talk in issues that are very important for judicial independence. And in that fight, in that battle, the Baka judgment is a very important point of reference. And in the coming months, we will see a government that has constitutional majority will pass legislation that will bar judges from being able to speak up, or will maintain a situation where you have at least this kind of ambiguous situation, and the bravery, the absolutely really existing bravery of Hungarian judges in matters that are important for all of us, because obviously judicial independence is not important for the judges, it's important for all the parties, for them, and the whole of society. Thank you very much.
So, I think we will quickly move over to Mr. Wittrup and have some ideas about the economical consequences of the judicial backs or democratic backsliding and the absence of independent judiciary. It's a very interesting facet of the problem because it goes to the heart of economic growth of our countries and the possibilities to take up the competition with the United States and other parts of the world. So please elucidate us.
Thank you very much. So I've been working as a consultant on many judicial reform projects around the world over the years. I think it's so trying to strengthen the capacities of judiciaries, that way their independence. And I think it's healthy for somebody like me to sometimes stop and reflect, why is this important? Why am I doing this? Does it bring any value at all to society? And so having this opportunity is one reason I'm delighted to be here today. And I think it's healthy for all of us to consider this. Why are we doing this? Why is readers important, but why? So the perspective I will bring to the table will be from that of economics. And the question in economic terms is, does judicial independence contribute? Does it help to bring prosperity? Does it help us to increase welfare? Does it increase economic growth? That may not be the only thing that's important about judicial independence, but it's quite important, right? And the answer to that question, provided by economic research, is absolutely yes. And to substantiate that claim, to support that claim, I will bring to your attention some important elements of economic game theory. I will highlight some research findings from history, and finally present some empirical evidence from quantitative studies on the relationship between judicial independence and economic growth. So if we go to the next slide, I'll start by introducing a very important concept, that of social trust. So in a survey, you can ask people, do you trust other people in general? And some people will answer, yeah, most people can actually be trusted. And other people say, no, you have to be very careful dealing with other people. And what's interesting is that the answers you get is very different from one country to another. And I've brought an example of some of the distributions of answers here. So this is from the Integrated Values Survey from 2022. So you see that, for instance, in Denmark, Sweden, and Netherlands, the majority of people trust other people. And if you go to Albania and Zimbabwe, almost no people trust others. Why is that important? It is important for the economy. Because in a modern economy, economic activity is all about collaborating people, right? And if you lack trust, you also lack a lot of opportunities for economic activity, because people are not willing to engage in it. So, for example, if you're in a low trust society, there's a limit to the types of companies you will have. You can have small family businesses, because probably trust, right? Okay. And you can have really large corporations, because they can have big monitoring departments, making sure that people are not shirking too much or not stealing the equipment. But that's basically the types of companies you can have. But you cannot have those really important mid-sized companies that have been proven to be crucial for a vital economic development. So that's I'm not going. I'm not there yet. So that's I'll give you a sign. So that's of course a problem if we have this lack of trust. Economists they have replicated these findings from surveys by having experiments, people playing games. Now I'm venturing into games. Game theory. People playing games with each other. So an example could be, let's take, I'll hit on the two. What's your name again? Tommaso, and you?
Eva.
Tommaso and Eva. Let's say we're playing a game together, okay? And I hand you maybe 100 euro each, okay? And the gameplay is like this. Tommaso, you'll decide whether you will trust with your 100 euro. And if you do that, I'll promise to double the amount. So Eva will suddenly have 400 euro. The final step will be that Eva has to decide whether she'll hand you back half of that. But of course, if you are in a low trust situation, you will think, oh, she'll just keep everything. So I'll not give, even though we can together make more money, I'll not hand her over that money. So if you play that game in Denmark or Sweden, most people will end up with a total of 400 euros. But if you play that game in Albania or Zimbabwe, most people will end up with just 2. So that's an illustration of the impacts, the economic impact of this lack of trust. This is important because there's evidence that social trust is highly related to trust in institutions, to trust in the fairness of the system. So if you live in a system you consider to be fair, you also tend to be more willing to trust other people. And that's one way that independent, impartial judicial system can help bring prosperity to society. Let's turn to another important game. So this is called the fundamental political dilemma. Because as we've been aware, at least since Thomas Hobbes, we need to create a Leviathan, right? We need to create this monster called the state to help protect us against foreign enemies, to keep some basic law of order, prevent us from killing each other all the time. But when we create that monster, the state, there's of course the risk that it will turn against us. And that's also a really severe problem from an economic perspective. But let's say you are a private citizen and you consider engaging in some productive activity. So maybe you will make an extra effort. Maybe you will try some test some innovative ideas. And if you succeed, you will make a profit, you'll create wealth. But you now have this monster, and maybe that monster will actually confiscate your wealth. And if you look at our long human history of autocratic rule, we can see that has happened a lot. So the rational actor in such a situation may decide, no, I'm not going to make an effort, just try to. That's it. So this is a bad game, right? So the idea is we could try to improve the game. How can we improve the game? So the sovereign monster should somehow be able to credibly commit to not confiscate the wealth. How can this be done? Basically in 2 ways. You can change the incentives of the game, make it costly for the sovereign to confiscate wealth. That's difficult. In the Middle Ages, it was usually done by hostages. So if you had a very important deal you made with an absolute king, you would exchange hostages for probably a prince or a princess. That was part of the job description if you were a prince or a princess. Become a hostage. That could increase the cost of breaking a promise. Another option would be to simply remove that option to confiscate. And that's, of course, where an independent judiciary and other important institutions come in here to create these checks and balances that disallow certain actions from happening. So that's from an economic perspective what we want to do. We want to, like Ulysses, meeting the sirens, we want to tie him to the mast. So even though he really wants to follow the sirens, he can't do it. That's the aim of having an independent. So let's go to the next. So what I'm saying here is there are several ways rule of law, including judicial independence, can help and contribute to economic growth is by providing this credible commitment that even though governments in all countries sometimes want to do something they really shouldn't do, that they're prevented from doing it. And the second way the judicial independence law can help economic growth is by providing this sense of fairness that increases social trust between people. So that's from a theoretical argument why we want to have judicial independence. So next slide, let's look at economic history. So what economic history can tell us is that judicial independence is really an important element in a set of institutions that have broken with the traditional way of doing things that we have seen for most of the human history. So for most of human history, what we have seen is what has been termed as extractive institutions, and this term has been coined by Nobel Prize-winning economists Daron Acemoglu and James Robinson. So what we have seen is that a small has really extracted all the value from a large group of people. And they have done this in the system with insecure public lives, with protection of vested interests, concentration of power in the hands of the few, and no really constraints on the power. And if there were a judiciary, this was certainly dependent. And we have seen that the modern time, the economic development in the modern time has depended very much on breaking away from this path and creating inclusive institutions with more equal distribution of power, checks and balances, including judicial independence. And this, of course, happened, first of all, in England, because our lives today is really as they are because of the Industrial Revolution. That's the most important event in the last 500 years. The Industrial Revolution happened here. Couldn't have happened in Spain, couldn't have happened in Russia. It happened in England for a reason. Because England gradually developed some rather inclusive institutions. And this started a very long time ago. Actually, well, you have heard about the Black Death, killing almost half the population in Europe. And what this created was actually it increased the bargaining power of peasants because there were a lot that was elected. So in England and Western Europe, serfdom was limited or closed because you couldn't. You wanted. They had much more power. Were much more important. You couldn't ignore their demands, or you could actually, because in Eastern Europe you had the same thing happened. Half the population died, but unfortunately here the extraction just became even worse. So you saw this two different parts already following the Black Death. Then you saw when the New World, when America was discovered, in most countries, the transatlantic trade was monopolized by the king. That did not happen in England. So you suddenly strong economic actors were established with interests that did not coincide with the king, with the interests of the king. So you had some interests established that were actually wanted to limit the power of the king, and that happened foremost of all in following the Glorious Revolution in 1688. And following that, we got judicial independence gradually developing in England. And following that, we had the Industrial Revolution, because suddenly you had a new game in relation to the fundamental political dilemma. If you innovated, if you did some extra effort, you could keep at least some of the game. As you couldn't have done in Spain, or you couldn't have done in Russia. So that's why the development of inclusive institutions started in England and spreaded this, both the Industrial Revolution, of course, but also the institutions that supported this Industrial Revolution to the rest of the world. So I will not, because of lack of time, you could also find other examples. Korea started as the same country, same genes, same population, and of course with different institutions developed in quite different ways, as we all know. I'll not go into that. If you want to read more, I would encourage you to read these two books by the recent winners of the economic prize. They're really brilliant, explaining this economic history and the importance of inclusive institutions and judicial independence. So just to emphasize this, institutions matter a lot. It's not about, you're not born as somebody who trusts others. You're not born as corrupt or uncorrupt. As an example, I'd like to mention that I come from Denmark, and Denmark is often rated highest when you have these comparisons, judicial independence and trust in the judiciary, lack of corruption, and so on. I'm not, yeah, okay. But actually, if you look back in time to the end of the 18th century, Denmark was a deeply corrupt society. So if you wanted to be a judge, you bought your position. And the way to make that investment pay off was to take bribes. That was the system. What happened? Then we had a king, Fredrik VI. In many ways, one of the worst kings. He he was a fan of Napoleon. He thought Napoleon was God, and sided with him all the way to the end. That was not a good decision. So we lost Norway to Sweden, and the state went bankrupt. And he was a little afraid that people were not satisfied. Maybe they would think of toppling him. So the story goes that he asked his advisors, "What are people? How can I make people more satisfied? What are they most dissatisfied about?" And the answer was, "That's probably corruption." Okay, let's do something about that. So he really sent the Supreme Court around auditing all the judges, making some symbolic executions to show that this is not tolerated anymore. That was actually an important step in eradicating some of the corruption in Denmark. And then one of his successors, Fredrik VII, he was only interested in drinking and women. So he was happy to have a parliament still. So that way we had some inclusive institutions. But it's not you're not born with that information. So just to next one. So I'll be very brief. This is some of my own studies using data from So World Economic Forum measures perceived judicial independence by surveying a large number of business executives. And if you run a regression with this component as an independent variable and economic growth as a dependent variable and uses all the usual control variables, we will see that perceived judicial independence has a clear and significant impact on economic growth. Actually, also the point you made earlier about the time for enforcing enforcement also has apparently an impact. So the faster your enforcement is, the better it is. So that's and this finding, this is my study, but a similar research has been done by some German researchers. They have established their own indicator of judicial independence, de facto judicial independence, looking at, for instance, whether judges continue to stay in their position until normal retirement age, whether budgets are not lowered, and so on. So then from that, they create a composite indicator measuring de facto judicial independence. And they find similarly that this has a clear impact on economic growth. It's important to say that this is de facto judicial independence, because if you try to measure just the rules, there's no impact. So just having the right thing on paper doesn't matter. It has to be real. And of course, there are also some important outliers. If a country has a lot of oil, it does apparently not need judicial independence so much. This is sometimes referred to as the curse of oil. There might be other bad things, but like independence, just having a bad economy, just the economy. And finally, of course, we don't have time to discuss that. There's China, which is also an outlier. But all in all, both theory, history, and empirical evidence supports the claim that judicial independence is extremely important for our well-being. So that's something we should remember, especially in these times. Thank you.
No, thank you. This is, I would say, great. It gives us hope. We've seen the political side and seen that it promotes good government. But of course, if that government can produce monies for us also, that is much better. I will try rapidly to summarize what we have discussed, because the time is running. Should I ask you if you want a question? Yes, please. You get here. I mean, you know.
I happened to go to Moscow with a rapporteur from Parliamentary Assembly, Sabine Neuss-Schnellenberger, who was also Minister of Justice in Germany, during the Yukos report that she was preparing. And we met the Russian Minister of Justice, whom Mrs. Dr. Schnellenberger criticized for lack of independence of the judiciary. And the Justice Minister was very clear at the time, at least, that judicial independence was important for economic growth. So they wanted some. Of course, they also basically asked back, you want us to fight corruption in the judiciary, and you want the judiciary to be independent. Now, what do you want? If we want to eradicate corruption, we have to control the judges closely, and if you want them to be independent, they will continue to be corrupt. And what her answer was, I found quite memorable. She said, well, of course you have to let the judiciary be independent, because you can't have them a little bit independent to fight, to do the economic growth thing, you know, to give institutional security for investors and all that. and then keep them dependent for whatever you want to do. As a woman, she said, she dared say that, it's a bit like being pregnant or not. You can't be a little bit pregnant. You have to be independent or not. I wonder if that is true, if it is possible, maybe in some less than democratic countries, that's the plan, to have judiciary independent, leave it independent on 95% of the cases that are not politically relevant, but just keep the economy moving, and keep control over the 5% cases that are politically relevant, that go to the question of power. I wonder, I mean, I strongly admire Mrs. Lange, but I wonder if she was right. In your view, can the judiciary be partially independent and politically controlled for cases that concern the question of power, democracy?
That's a very good question. You probably can't provide an answer to that's satisfying. So the benefit of having this long perspective, looking at economic history, is that it's a long time, and you can see but as a society, we really want the solution tomorrow. We want the current judges to be uncorrupt and independent, and that's of course if you're starting from a very bad position with regard to these aims, that's difficult. I don't know. We've seen attempts, for instance, in Albania with this vetting process, trying to get rid of, to make clear that you only have the good judges left. That has been difficult, certainly. And it's also seen Eastern when in Eastern Europe, some attempts to try to put out the bad judges. This was done differently in different countries. I'm not sure I have any quick solution. That's very difficult to live.
Can I add something? Yeah. Thank you very much, Gunther, for the question. But trying to answer that, probably we should start with defining what corruption is. Because to my understanding, you have financial corruption, but you also have political corruption. The judge can be paid from the money of the parties. The judge can be paid from the salary he gets from the government. For me, there is no difference. In some cases, political corruption is the very source of the financial corruption. Because as you mentioned, if you have to pay or favor to the government facing an individual and limiting the rights, and the government tells you, well, you shouldn't recognize the rights of this individual because this is my interest. Then the judge would say, what in another case? Where is my direct interest? I'll follow my interest. Why the minister shall find his way or her way and I should not? So there is a question of properly defining what corruption is, and I think the political corruption is really discussed. For example, in Albania in the 90s, the real problem was not at the beginning the financial corruption, it was political corruption. At the time, the first Albanian kind of democratic government started to interfere with the independence of the judiciary in relation to the political opponents. And then it spilled over the civil cases, commercial cases. So that's for me the source of the problem. But I agree with you. You either are corrupt or an independent, or either are corrupt or you are independent 100%. Otherwise, it can't.
Can I just? And one more thing is that economic cases become politically sensitive in the system after a while. So you cannot keep them apart, and at least that is the Hungarian experience. That what starts as an economic case, as money runs out, politics needs money, so it's gonna be political. So there is no way of we are okay for the economy, but we are deciding in favor of the government for political cases, because it's gonna come together. And I think this is something that certain foreign companies are experiencing now. Eventually, this will come and yeah, catch up with.
Thank you. May I ask Teoman, are we allowed to stay longer than 5?
Normally, yes.
Okay, no, fine, because I mean there are plenty of things left. I have a small conclusion to make. I'll try to be very brief because I think that we have covered a lot of ground, and still it's possible to put down in not too the difficult or complex terms what we have met here in the discussions. One, if I start with the importance of judicial independence, yes, it's very important to protect democracy, in particular to protect against executive abuse of parliamentary trust. But of course, there is a problem, that is, you may have to control parliament also. Some states allow judges to do that. Hungary started, but it's a complex thing. There, it's rather the European level which will have to come in, whether it is the EU or the Council of Europe. But so then it becomes the independence of the judges over there. It's not lost, but it just transposed one level up. Then we have the fact that it promotes economical and social progress, the aims of the Council of Europe. We've heard a lot about the different facts here, and the word I retain most is trust. If you trust, you engage in business. You don't have to have huge insurances because you engage, because you don't need them. And you can also extend the trust to other nations, and then you can start to have exchanges between nations in a safe way. And all this evidently builds a lot of economic wealth, and we can go into further details. But I think you did say that there were really statistical evidence that judicial independence was a very important factor in this growth scheme. The other thing is that, notwithstanding these advantages, there is democratic backsliding for different reasons, and we didn't really go into them, but it's a fact. And one of the first victims is judicial independence, because those who take power and think that they have full mandates, they don't want to be controlled. They want to be able to fulfill their mandates, whether it is for the good of the people or for their own interests. And I think often the latter is more true than the former. And we also found that it was very difficult for national judges to resist this backsliding, because there are so many levers that the authorities have to control them. And we've seen plenty of them. There's control over pensions, the control over salaries, the control over how the Supreme Courts are organized. There is ad hominem legislation. There is ban on publications. You name it. There are many, many ways in order to get a hold of a judge's career and sanction him if it doesn't please the government. Yalçınkaya showed another thing, and that was perhaps you don't need to get hold of the whole of the judiciary, just hijack the Supreme Court and have it adopt a very strange decision, and then the lower courts as good soldiers just implement it. But this then brings us to what can Europe do then, if it is difficult for the national authorities to come to grips with this? And we haven't really dealt with the EU yet to any greater extent, but it's evident that it has a lot of economic clout, that it has not been afraid to use it. The European Court of Justice, which, as we said, had developed a rather substantive and well-defined approach to judicial independence. But of course, it doesn't reach the whole way, and it's difficult to reach. On its face, the European convention system is better. It's accessible to everyone. But we're also seeing that it has encountered big problems because many hurdles have been put up for individuals to come before the court. We've spoken of massive, and we've also seen that even these can be abused by domestic states to protect against the European control, the one in the Council of Europe, by ensuring excessive reliance on friendly settlements, controlling the government agents so that he loses power, and in fact it becomes rather direct dialogue between the ministers and the ministers. And that is a political dialogue which is not so close to reach concrete results in the same way as more diffuse level, which is the different civil servants which exist both domestically and in the Council of Europe. There are a number of interesting developments. On the one hand, the long time it takes usually can be shortened. In Yalcinkaya, it took 3 years. We saw Prima Signore, it took 3.5. So perhaps if you do select the right cases, you can get somewhere in fighting judicial attacks to judicial independence, especially as the execution process is a very open process, which is available to many different authorities and also to other international organizations, and one which can take binding decisions and which also has a great, so to say, outreach in the world, in the sense that what happens there can help to influence other players around, whether it is the EU, whether it's the United Nations, whether it is the World Bank or the International Monetary Fund and others. I experienced plenty of discussions with these bodies during my time there, and it has huge potential, but especially when it works together with others, like the Parliamentary Assembly, like the regional authorities, with these other partners which you may find inside and outside of the Council of Europe. So there is globally a big problem, and the most important thing to come to grips with is probably the European level. That's the most important tool which can reach out to try, in the context especially of the execution of judgments or in procedures before the European Court of Justice, to all these different aspects which are not in themselves rights under the Convention, but there are elements which can be taken into account in the execution process to ensure a result which is Convention compliant. And there we can look at how the Judicial Council is composed. We can look at how the salaries are defined and all these things. But all this requires a lot of investment, political and economical, and perhaps awareness also in the institutions. But I would say that the case is not hopeless, and especially if it is driven by a number of carrots, namely better democracy, more money. There are chances that we will be able to mobilize around it. Thank you. And then you take the floor and you guide.
No questions. So maybe we can take 5 minutes for some questions.
Yeah, no, if you are not very hungry, I presume that. But of course, we have a microphone here, and please.
To ask about the qualifications of the case from the EU. So how does the case and also overall issues of judicial independence in the country play into infringement procedures against Hungary? Now, you, Lady Bianku, already mentioned that the case served as a reference to the Court of Justice of the EU. So I would like to hear a little bit more about that.
Or perhaps you?
Yeah. You want to start? And
Yeah, the Baka judgment was mentioned by the European Court of Justice in the Polish line of cases. This is brought first by the European Commission, and the first was decided in June 2000. In all the procedures brought by the Commission before the European Court of Justice, and through the preliminary rulings, so cases brought by, for example, KRS, all these cases, it's a special procedure in Luxembourg. So a judge at national level suspends the proceedings and asks the European Court of Justice in Luxembourg for an opinion how the EU law would apply in such a case. Baka was mentioned, so the principles elaborated by Baka. As far as I know, there haven't been infringement proceedings by the Commission against Hungary on the independence of the judiciary. They've been in Soros law, in some discrimination law, property law as well, but as far as I know, not in relation to the independence of the judiciary. However, I use the opportunity to mention something which is extremely important for the EU law as such in the operation of the EU. Why the EU court, the European Court of Justice, was brought to tackle the issue of judicial independence. And this is curious. If you read also the precedent of the European Court of Justice, who has been instrumental in these cases, Kundens, he also expressed this. The European communities and European Union was thought as an economic kind of way of integrating Europe. So not dealing as such with fundamental rights, freedoms, liberties, all this was taken for granted for years, at least until the 2000, when the Charter of EU Fundamental Rights was signed and elaborated in Greece, and then entered into power in 2009. Then it is interesting how the court says, we will tackle the issue, because the Polish government, before the European Court of Justice, said, listen, this is the competence of the EU member state. You do not have competence to tell us how to organize our judiciary. And the European Court of Justice said, listen, I have in place this procedure that I just mentioned, the preliminary rule, which says that national courts can suspend the proceedings, ask me questions, and then in return, when I reply, they have to apply EU law. And it says, if the national court is not independent, this procedure, which is probably the core of the operation EU law, wouldn't work. So they see the independence of the judiciary, and I make a link with what you said, as instrumental, as critical for the purpose of the operation of the common market. Because the preliminary ruling, they concern whatever economic issues, free movement of goods. For example, the famous case, Cassis de Dijon. Can a liquor produced in France be sold in Germany or not? This was asked by a German judge. If this German judge was not independent, when implementing the answer, I'm going back 1979 is the case, when implementing the judgment of the European Court of Justice, the government would say, well, you have to apply it this way. So the independence of the judiciary is fundamental for the operation of the Common. So this is the idea why the European Court of Justice intervened with a series of judgments, mostly towards Poland. And as Fredrik mentioned, also using its economic power. I remember at the time the vice president of the court, in the middle of COVID pandemic, remember the date, 8th of April 2020, everything was closed. She went, was the former Portuguese judge. She went to the Court of Luxembourg and adopted an interim measure, 500,000 euros per day. Delay of implementing the judicial reform, which was then brought to 1 million per day, etc. So they're very much using this tool to force the reform. I don't know if I was a response to your question.
Just a couple of things. One reason I think is the reason that I mentioned, that in the case you have much more incremental measures and much more subtle methods of occupying the judiciary. So the attacks on the judiciary were not so blatant. Therefore, it was more difficult to create those cases through which preliminary references could have been raised. And it was much more difficult for the legal service of the Commission to find a handle on the Hungarian judiciary than it was in so forth. Just to give you an example, the retirement of judges, that went to Luxembourg, but not as a judicial independence case, but as an age discrimination case. So at that moment, actually, the Commission was not really prepared to look at systemic independence related aspects of the case and handled it as, older judges are treated fairly and did not really look into why. And then the court solved that case on the basis of non-discrimination. I expect that there might be some cases, as I mentioned, there is or I may not mention that, there is actually over 100 complaints from Hungarian judges with the Commission regarding the salary issue and how the Hungarian system of judicial salaries or determining judicial salaries are in line with the Portuguese judge's case, where the Luxembourg court said that actually the remuneration of judges is an important element in judicial independence. So there we are actually waiting for the Commission to decide if they will go to the infringement procedure or not, but they have complaints from the judges. And also I expect that in the future, this case might actually reach the CJEU, because as you could see, the situation is accelerating and it's not as subtle anymore as it used to be.
I could perhaps, yes. Well, you.
The question is from a woman who follows the panel on YouTube, and I will read this question out. So the question is mainly to Professor Kaminski, but other panelists as well. Welcome to comment on the question. So the Grand Chamber hearing of Yalcinkaya case, the hearing lawyers of Yalcinkaya about judicial independence in Turkey as well, by reminding that 45,000 judges and prosecutors dismissed over a single night after two attempts. So why was the European Court of Human Rights reluctant to address the issue of judicial independence in the Yalcinkaya case? Is a separate violation, my asks. Thank you. I answer very, very briefly because there is no provision on judicial independence. There are rules on, right to fair trial, on the provision of penalties. So we should refer to such, provisions in order to construct our allegations. So we must work on the human rights level, not on the level of some principles. That was even easier, I would say, for the European Court of Justice, because under the some procedures traditionally reserved for economic issues, it was possible to accommodate some political matters. It happened after this Portuguese case. But if you look, the opinion of the Advocate General presented before the court decided this case, the Advocate General was against this broadening of the competence of the European Court of Justice. So also within the European Union, there was a huge discussion, legal discussion, on whether the European Union is entitled to accommodate some political questions within the framework of traditional procedures of non-violation of European Union law. So the argument was that if there is a crisis concerning the judicial system in a member state, some other legal avenues should be used. This was all Article 7. So only if there is unanimity in the European Union, this procedure could be activated. But the answer of the European Court of Justice in this Portuguese case, so this audit decision, not the opinion of the Advocate General, was different. We can go into this issue using some provisions from the treaties, which have been considered before as only being visible for other questions, not political issues. So that was a kind of revolution, this Portuguese case. But in the framework of the European Convention, this kind of revolution is rather possible. So we must focus on concrete issues regarding particular provisions, guarantees of the European Conventions of Human Rights, nothing more.
Can I express some hesitation about the lack of competence of the convention? Because, of course, there's a question of who can complain. But it's clear that people who see their rights affected have, or who deal with civil and political rights, civil rights or obligations or criminal charges and so forth, have a right to an independent tribunal. And there is quite some case of the European Court of what that is, independence. And the European Court has even found that the internal independence within the Supreme Court in Ukraine was problematic because the president of the court had too much power and so forth. So I have some difficulties seeing that there is no grip for the European Court to attack independence in the convention. But of course, it cannot be attacked like that. At the dinner yesterday, we discussed whether a judge could claim that he started to lack independence because of pressure he was exposed to. It's a new kind of complaint. Possibly it can be linked to Article 8 and his dignity as a judge is offended by the fact that they try to induce him to do things that he doesn't think is in accordance with his judge oath. but I mean, it's untested ground. But it's clear that we can go into independence, and especially when you have a finding of arbitrariness or something like that, the committee ministers, when it controls execution, can certainly go in and look at independence in all sorts of forms. We went rather deep into the Azeri situation. We tried to look into the Hungarian situation also. Now, how far the committee will be able to go depends a little bit on what is the willingness of the other states to push. And that depends also on the EU, how far they think it's worthwhile the Council of Europe. So it's a complex game, but certainly there are a number of avenues whereby the Council of Europe and the European Court and the Committee of Ministers can dig into independence issues. So I'm a bit more optimistic than you, but perhaps I misunderstood what you said.
I do agree with you that perhaps there are some possibilities in the council that in the common committee of ministers in the framework of the implementation of judgments, because the European Court formulates a conclusion its judgments, but there is a more complicated, complex process of implementation of the changes on the national level following particular decisions, particular rulings of the European Court of Human Rights, and it's up to the Committee of Ministers to perhaps choose some options, political options for reforms. So, of course, the committee starts for a particular case, but to put this case in a bigger perspective of how some institutions operate in a particular country. So I do agree with you that perhaps there's something for the Committee of Ministers, but you must also remember that the Committee of Ministers is composed of ministers, politicians. So it depends on some strategies built within this body by political groups, political party. You are familiar with this, system.
You are right. Civil society can do a lot of strange things. It's not uncommon that, for example, at some stage, we have some government asking us, what are we doing in this case against Hungary or this case against Turkey? We have a question in Parliament back home asking us, what is Denmark, what is France doing in the Committee of Ministers to ensure that these problems in Turkey or in Hungary are solved? And then suddenly things become more complex. It's outside of the local government's control and even of the government sitting in the Committee of Ministers, because suddenly there are new stakeholders which have announced themselves. But to create those kind of pressure, it's like leading a big military campaign. It's a big so to say adventure, and you have to find your friends, and you have to spare your resources because and you have to have a plan, etc. That kind of situation doesn't arise very often. So frequently you are right, but not always.
Just clarify something in relation to your question. It is true that the claim was raised before the court in Yalcinkaya, before the Grand Chamber, but it depends very much how do you raise the claim in Strasbourg. And there is a difference with the procedure in Luxembourg when the commission, because the commission in Luxembourg before the Luxembourg court can raise general claims about the status of the Polish judiciary, Hungarian judiciary, any judiciary of the member states. When you plead in Strasbourg, one of the major criteria under Article 35 of the Convention is that you have to be a victim. So you have to, and in this case, this was the problem in relation to that claim. You have to argue why the judges deciding that specific case were not independent. And the court answers, because I opened the judgment just to be sure of what I was going to say. answers this issue in paragraphs 363 and 364. And the nuance, the language of the court is, let me say, curious and interesting. It says, I note the problems International Commission of Jurists was raising as well. But these, the court says, are general problems, and it is not the role of the court to make statements about the general situation of the Turkish judiciary. You have to come with a concrete claim, specific victim status, which then might lead the court eventually to also to state under Article 46 of the Convention general measures. But to come as such with a general statement about the situation of the Turkish judiciary, it's difficult. You have to plead the victim status in strong. Exceptional.
Yeah, no, I feel engaged to respond to this, because it's perfectly true that the court will not do this, but the committee ministers will. And in the cases against Hungary, against Turkey, for example, Kavala, the ministers has found, having looked at the position of or the knowledge of the other states, having looked at the information submitted by NGOs and possibly having read reports from the United Nations and others, that no, there is an absence of protection against interferences with judicial independence by the executive, that is threats of prosecution or God knows. And there's also a problem of independence of the Turkish judiciary in general. That means the composition of the Council of the Magistrature, which decides upon promotions and other things. So the kind of statements you need in order to build a case can come from the committee ministers instead. And they are pretty authoritative. Founded, supported by all the government. Most of these decisions are adopted by consensus. It can vote also, of course, if it wants to, with 2/3 majority, or a bit more complex, but still. But it usually doesn't want to, because it's difficult to ensure execution of a judgment against the will of that state. It's easier if you can do it with some kind of consensus approach. But sometimes the committee has forced its way and gone quite some way, and you've seen that in the infringement proceedings in the Ilgan Mamadov and in Kavala. But then, even if you go that way, remains the question: what shall the committee do after the court has confirmed the committee's conclusion that there is this respect of the obligation to abide? Well, now we all agree that it is legal obligation, not just a political obligation. But still, things need to happen. But the experience is that often things change, like with Poland. Politicians are not eternal. It's like educating children. You put constant pressure. Sometimes they give in, and then you're there, and then you make them move forward. After due time, you have gone quite a long way with them. But that was just a small comment. I'm not sure. Are there any further questions around? No, because if there are not, I think we should thank the organizers. This was a beautiful event. Thank you so very much for have taken the initiative. A topic of very timely. Thank you so much.
Hi. Hi. Bye bye. Let's do a intro.
Oh.
Ooh.
Oh yeah.
Okay. And